Thanks for being here. I would like first to thank the organizers for inviting an ICC veteran. I feel very honored. I suppose it is one of the last times because, you know, for a veteran, you never know how long the good things will last. So I have my glass of water in case I collapse. So in addition, I have to start with an apology. I have no PowerPoint presentation. I'm going to speak in my usual Franglish, so good luck with it. And lastly, my colleague Rod and Carsten Stan have already covered quite some ground with respect to prelim examinations, so I don't have much to tell you in addition. But you can already use the evaluation sheet that you have in your kit, so that so if you have complained against any ICC veteran, you have a way to convey that. In fact, so I was requested to discuss the analysis of communications by the Office of the Prosecutor of the ICC. And in fact, it is an aspect of the prelim examination process that is probably not very much known, not as well as the other phases on the analysis that we do on subject matter, complementarity, gravity, and so forth, that have been addressed before. So I think that the topic is quite interesting, and actually I do have a couple of things to convey, and that will also be a way of responding or following up on José's presentation on Mexico, and also would be a good transition to Bill's next intervention. So in terms of, first, what we mean by communication, I mean, as you may know, the term is actually not used in the statute. It's a term that the OTP has created. The communication means information on crimes, basically. And these communications can be sent to the office in multiple forms. Can be a report, can be a letter, can be a video, can be anything, by almost anyone. So any individual, any organization, any state, any government can send communications to the office. We receive plenty of correspondence, but we only register as communication this document that includes information on alleged crimes. In principle, these communications are meant to be confidential. That's the main difference between communications on one hand and open source information on the other hand. Pursuant to Rule 46 of the Rules of Procedure and Evidence, the OTP, or the prosecutor, has an obligation to maintain the confidentiality of these communications. That is also one of the reasons why we don't report on these communications and on the way we analyze them publicly. But in fact, even though we have to protect the confidentiality, very often it happens that either we receive a communication that includes open source information, so it's not exactly the purpose, or it also happens that the communication senders make the fact of their communication and sometimes even the content of the communication public. They post it on the website for advocacy purpose or for other reasons. So in my presentation, I will refer to some communications that we have received, of some situations that have been brought to our attention through communications, only because it is a fact known that these communications have been sent to us. So we rely on communications to a large extent, in particular for assessing jurisdictional issues. But I should qualify this a little bit because, first, a single communication is, as you may expect, not sufficient to trigger a prelim examination, or even less to trigger an investigation. So we use communication in addition to other material. And precisely, the communications are not our only source of information. Obviously, there is open source information, there is social media, there is information sometimes that is submitted to us in support of a referral or a declaration of acceptance of the court's jurisdiction. But still, communications are important for us at different stages of our activities, different stages of proceedings, to decide whether to open a prelim examination and to carry out a prelim examination. And often when we seek authorization from the pretrial chamber to open an investigation, the material may include Article 15 communication that we have received during the prelim examination. And even during the investigation, some communications can be useful for identifying leads, for instance. So we use communications very often and quite extensively. In the interest of time, I will focus this presentation on what we call phase 1 activities. Carsten has reminded you of the 4-phase approach that we follow. Phase 1 is the initial review of communication, and 2, subject matter, 3, admissibility, 4, interest of justice. So I will focus on phase 1 because this is actually the least known aspect of our work, and this is also at this stage that we deal with the bulk of communications that we receive. And it is also at this stage, at phase 1, that the decision to open a preliminary examination is taken by the prosecutor, when this decision is not automatically triggered by a referral or by a declaration of acceptance of the ICC. So this is an important phase of our process. There was a time where the decision to open a preliminary examination in a given situation could be taken relatively hastily. Now, I mean, since then, especially in the past 4 or 5 years, I mean, the process has been much more structured. And all our own analysis, the analysis done by my section, and our recommendations are all submitted to the prosecutor, the senior management, for a decision to open a preliminary examination after a thorough consideration of the matter. So we have I think we have a robust system in place. Excuse me. On average, we receive about 500 communications per year. Last year it was 502 exactly, and that's the average. And then so we receive communications every month, every week. We deal with them on a monthly basis, basically. And the first thing we have to decide is what these communications relate to. And then you have 4 possibilities. One possibility is that the communication is manifestly outside jurisdiction, MOJ. That's our terminology. And actually, it still applies to about 70% of the communications we receive, which I find a bit annoying. I mean, almost 20 years after the entry into force of the statute, because it means that some people still have not understood that the ICC has jurisdiction only on the territory of state parties, only after the entry into force of the statute, either in 2002 or at a later date. I mean, these types of very basic parameters, or that the ICC is not the proper forum for corruption claims, this type of issues. So a number of communications are manifestly outside jurisdiction for these basic reasons. That's the first category. Then you have a second category, which are the communications that are relating to an ongoing preliminary examinations. So it's very easy. We keep receiving communications on Colombia and Afghanistan, Palestine, and so forth. And it's true that the fact of opening a preliminary examination triggers even more communications because people know the ICC is looking into it. But that's useful for our work. I'll come back to that at the end of my presentation. The third category are communications relating to an ongoing investigation or prosecution. So for instance, for an investigation ongoing in the DRC, we receive communication relating to DRC situation, so it is then forwarded to the team that is in charge of investigation. And the last category, the fourth category, which is possibly the most interesting, there are communications that do not belong to any of the first 3 categories, but there are communications that we call them warrant further analysis, WFA, very important acronym, warrant further analysis. So these are communications that are not manifestly outside, but it's not clear whether they are within the jurisdiction of the ICC. And that's why we need to do further analysis, because we cannot dismiss them. And in fact, these communications, or the situation they relate to, are then subject to a dedicated analytical report. So for instance, we have a report on Mexico, a big one actually, and on a number of other situations. So beyond the 8 preliminary examinations that are reported in this very nice booklet that I wanted to show you, by the way. So this is the report on preliminary examination. It's for free. I'm not trying to make them business. That we publish every year in French and in English. And here you will see that there is a chapter on each ongoing preliminary examination. But in addition to these situations, we have the phase 1 situations relating to the WFA communication. Are you following? Yeah, more or less, okay. So in the past 3 years, we published about 30 reports. No, we did not publish precisely. We produced about 30 reports on this type of situations brought to our attention through communication. So obviously, I'm not going to go over each of them. First, because most of them are confidential. Second, because it would take too much time. But we recently we have come up with we have looked back at our work, and we have come up with a sort of typology of this type of WFA communication or type of situations that we look at under phase 1. And there are 3 main types of phase 1 situations, so subcategories within these categories. One is what we call the due diligence situations. So basically, the allegations that are sent to the office are quite limited, and on their face, they are not manifestly outside, but they will likely not fall within the subject matter jurisdiction of the court. But we still have to do some research, some verification to be sure. That's typically the type of incidents, type of communication that is submitted to the office when there is a demonstration that is suppressed somewhere in the country, there is a political crisis, there is some political violence, electoral violence. So basically there are clashes or riots, but it's not an armed conflict, and the conduct does not amount to a crime against humanity. But we still need to have to do some research. So we receive communication relating to Djibouti, for instance, Congo-Brazzaville. I mean, each time there is political tensions in a country, basically. So we exert our due diligence. The second category relates to what we call discrete or unique situations. So there are usually situations where a specific legal or factual issue is raised. Often it has to do with the exercise of personal jurisdiction. So, for instance, we had received communications on the application of UK forces in Iraq, which has led to the reopening of this preliminary examination. But there is also the ICC issue, obviously. You may know that we issued a statement in April last year explaining the difficulties with exercising personal jurisdiction in relation to ISIS crimes. So these are really typical situations, I mean, quite specific. Another case that you may have heard about is the declaration, or the purported declaration of acceptance of ICC jurisdiction that was lodged by the Muslim Brotherhood from Egypt. I'm talking too fast. You know, when the Morsi government was removed, then he and his government, so to speak, attempted to accept the jurisdiction of the ICC, so we had to look at the eligibility of them and the validity of this declaration. So that was the subject of a phase 1 report. And actually the decision was negative, but ultimately there was a ruling by the Prosecutor Chamber on this matter. So these are very specific situations that we also need to look at. And the third category of phase 1 situations are what we call borderline situations. That sounds bad. Huh? So borderline situations, there are situations that involve complex sets of facts and allegations, often lasting multiple years, involving multiple actors. Well, the typical complex situation that sometimes we have to deal with. But often the problem is not only that the facts are complex, but the legal issues are complex as well. Because typically, like the situation of Mexico, there are situations with widespread human rights abuses, but it's not completely clear, at least to us, whether these widespread human rights abuses amount to crimes against humanity. I mean, usually at this stage, we mainly focus on crimes against humanity because there is no armed conflict in this situation, and genocide, I mean, luckily is not alleged that often. So we had this, Mexico is an example. We also have had Bangladesh until recently. Burundi, obviously, is another example. And Burundi, as you may know, is the latest prelim examination that has been opened by the office. That was in April of this year. Covering the 12 previous months. So basically, we have spent a year at phase 1, monitoring the developments in Burundi, gathering information before reaching the decision that the situation, to our assessment, warranted the opening of a prelim examination. Now, to be frank with you, sometimes we are faced with quite challenging situations. The determination of whether the crimes appear to fall within the jurisdiction of the court appears the standard that we use at this stage, as opposed to reasonable basis to believe. So this determination can be quite difficult to make. And in fact, the office is engaged in a policy reflection in that regard, to further decide, I mean, how to go about this prelim examination, these borderline situations, and what further considerations we should have to in order to make the decision whether or not to open a prelim examination. As a general rule, we are likely to be quite conservative in our approach. But this being said, I mean, I mentioned Burundi as an example, but before that, there are a number of situations of prelim examination were opened without a referral or without a 12-3, so on the basis inter alia of communications. That includes Afghanistan, Colombia, Guinea, Nigeria, Georgia, and so on. So even when being quite conservative, we still have a lot of work to do. But this issue with borderline situation, and sometimes the difficulties for us to come to the conclusion whether a given situation is a situation that the ICC was established for. But this situation, I mean, highlights the importance of the quality of communications that we receive, and by extension, I mean, the importance of the work that CMN has been doing for quite some time, the importance of the work that first responders are doing in the field, the importance of the work of Bill, and many others. I mean, all efforts at documenting alleged crimes, as precisely, specifically as possible, with the framework of the ICC in mind. I mean, these efforts are extremely useful for us and enable us to operate and activate our jurisdiction when necessary. And I must say that in the past couple of years, we've seen quite an increase in terms of the quality of the communications we receive. We still have a lot of MOJ communications, but we also, aside of those, I mean, receive communications that are very well structured, very well written, with a compelling supporting material. I mean, some people, and I'm sure this applies to some of you, I mean, do very good work in the field, and that's extremely encouraging for us and promising. So, and be assured that when we are satisfied that we have jurisdiction, we'll proceed without hesitation. That's it. Thank you very much. I'm happy to take your questions later on.
Thank you, Emeric.